Mr. Mander.
Yes, please, Lords, my lady. The final ground was that of the identification, or the failure to provide an identification direction. The Crown's submissions are to be found in its case between paragraphs 293 and 299, commencing at page 4131 of its case. Put succinctly, the respondent's submission is that the witness, Margaret Dance, did not purport to identify the appellant, and accordingly her evidence was not a visual identification. It was not a visual identification in terms of section 344D of the Crimes Act, which of course was the provision that was in force at the time of trial.
It occurred to me that one sometimes tests these sort of problems by asking whether the situation would be improved by having an identification parade. But her description of the individual, imagine getting a lot of people from the street and having an ID parade to try to test this evidence is pretty fanciful, isn't it, in view of the description she gives with this wig and all the rest of it.
It couldn't possibly hold an identification parade here. No. She didn't purport to identify anyone initially. It would only be if you purport to identify someone that it would be appropriate to hold an identification parade.
I suppose one point is a bit of physique comes into it, the sort of build of the individual, which was said to be similar to that of the appellant.
Yes, well, that's as far as it went. There was some reference to a round face.
And heavy and odd run and all of it. When did she come forward? I can't remember. It was before he was arrested, but it was some time after the murders.
It was quite early. She made statements which were actually produced in September. For some reason, I think the 5th and 6th of September.
Oh, there had, however, been quite a lot of television coverage which showed Mr. Lundy at the funeral and so on, hadn't there been?
I believe her statement was, certainly her first statement was taken before. Her statements are in the bundle.
That's all right. Don't take time on that. It's
in any case, she did not purport to be strictly accurate. There were 3 statements. The first 2 statements, taken very close to the time, a week afterwards, approximately, in which she certainly attempted to make no identification, either by comparison with any photographs she'd seen or anything of that nature. Those were the 2 statements that were produced at the defence insistence and went to the jury. She made a 3rd statement in about February of the following year, as I recollect, in which she did, as I recollect, mention that she had seen, she said she tried to avoid it, but I think she said that she had seen a photograph of the Lundy family. But her evidence at trial, certainly, that was certainly not led from her that she'd made any sort of comparison or anything of that type. And of course, Mr. Behrens limited what he put in front of the jury to those initial statements, which made no reference to a purported comparison with photographs.
Is there a principle in New Zealand law akin to that which obtains here, that where the prejudicial effect of certain evidence outweighs its probative value, that it should not be admitted?
Yes, my lord.
We also have a statutory provision. I can never remember whether it's Section 74 or Section 76, but Lord Hughes will correct me. Section 78, even worse, that permits enjoins a judge to to refuse to admit evidence which would be unfair. Is there any similar provision in New Zealand statutory law?
Yes, the Evidence Act presently provides for that type of analysis, and certainly prior to the Evidence Act 2006.
There wasn't any objection to Mrs. Dance's evidence on the basis that it was prejudicial?
No. No, and I, in my submission, there is nothing on the face of her evidence that,
if there wasn't an objection,
that would have, in my submission, potentially formed the basis of such an argument in my submission.
And the trial judge didn't omit to make a mention about the need for care in addressing the evidence. I mean, he did single this out as a thing that needed some attention. The complaint is really that it was a lack of the full warning that should be given on visual identification.
Yes,
That's
well,
really the point,
the learned trial judge made reference to, perhaps it's worth looking at that, at Volume 4, Tab 9 of the case. Volume 4, Tab 9, at page 1800. At paragraph 11 of the summing up at page 1806, there is reference to Margaret Dance's evidence, and the last sentence, which the appellant places great store on as being an attempted direction but not sufficient, is the reference by the learned judge. As I have already told you, you must always bear in mind that eyewitnesses can be convincing but mistaken. Now, he didn't earlier in his summing up.
Could
he wasn't
said,
so specific. Sorry, no.
Is there something there? I didn't think there was anything earlier in his summing up, but I wondered whether he might have made some prefatory remarks in opening, and he may have thought that this truncated warning was sufficient for non-identification evidence, but evidence of description.
Yes, ma'am. At paragraph 2 of the summing up, page 1800, the learned trial judge gives the standard directions regarding the need for the jury to make decisions as to the reliability of witnesses. About halfway through that paragraph, the learned trial judge states, in particular, you decide what witnesses you'll accept or not accept, and as you think fit, what parts of their evidence you accept and what parts you reject. It is for you to assess their demeanour and judge their reliability and their credibility, the very stock standard.
There is an indication in that paragraph that he did do some introductory remarks before the case commenced.
Yes, ma'am.
Is that the practice in New Zealand?
Yes, it is.
Sometimes in Scotland, where I come from, a judge might say that to a jury just to introduce them to the task they were going to have to perform.
Yes, certainly there is. It's sometimes difficult casting one's mind back when these innovations came in. But I note that Mr. Behrens made an opening statement before the Crown case, before the evidence was called, after the Crown opening. So clearly I think it would have been a situation that the trial judge would have given introductory remarks.
At any rate, we take it on the basis that really for practical purposes all we have is that last sentence. And the question is whether that's good enough given the nature of the evidence we're considering.
Indeed, and if I may take your lordships, my lady, to one case, that of Tariki, which is in the casebook, it will be in volume 3 of the bundle of authorities, tab 38, where towards this was a case in which the New Zealand Court of Appeal ruled had not involved identification, but it traversed the different types of description, circumstantial and direct identification, and attempted to provide labels, visual identification evidence, recognition evidence, and that type of thing. What is interesting to note is that clearly in that case, which was a similar case to this, where a witness had described a person and for the purposes of their evidence gave that description, the case is authority for the proposition that no such identification warning now contained in section 126 of the Evidence Act is required.
What are you referring to? Yeah, what paragraph?
I'm sorry, there's a summary at the end of the case, 3880.
It's quite a neat attempt to categorise types of evidence. And there's observation evidence and there's resemblance evidence.
Yes.
Which is this particular case? Mrs. Dance is doing what?
Well, Mrs. Dance's is over the page 3882 is observation evidence.
Right.
Observation evidence, on the other hand, is evidence about the actions of a person, including evidence of an offender's alleged participation in the offence. Differs from identification evidence because it's not the presence of the offender at the scene of the offence that is in dispute.
But that isn't this. This is not directed at this point.
No, that's, we know he was there. What did he do?
Yeah. It's appearance evidence, I suppose.
Yes.
It doesn't get as far as resemblance, it's just, just appearance.
General appearance.
Well, it is provided with a description. It is description evidence.
And what was the evidence in Taraki? Very quickly.
Taraki was a situation where a witness outside, as I recall, a club recognised and described paragraph 12 was the description that was given of this individual.
These things sometimes come up in other guises, that perhaps somebody sees a vehicle which that individual doesn't have any particular reason to link with anything, but other people who know the other evidence knows that there was a car, let's say a car, purple-coloured car or car of a particular type, and a witness is produced who said, well, I saw a purple car driving along this street at such and such a time. No, no doubt it's a visual identification, people might be mistaken and so on, but you wouldn't give the full identification warning in that kind of situation.
No, they can be as mistaken as any other witness describing an event or what they have seen. Of course, the great danger when a person actually makes a positive identification is they could honestly believe they have identified the person as such and such or as the person, but they are mistaken. And of course, that goes back to Turnbull.
Taraki looks as if it was a case of, as you say, description and really of observation, somewhere on the boundaries of description and observation. He agreed he was there. The issue was what he'd done.
Yes, and there
which of the people who were milling about had done what was seen? Is that right?
Well, that is it. There was an amalgam of evidence made up of different witnesses. Two witnesses who had seen gave identification evidence, recognition evidence because they knew the man, and were describing what he was like. He had an umbrella, he had the afro hairstyle, and they knew him from school, I think. So there was an identification. These witnesses came along and gave evidence of the man with the afro, with the umbrella, was doing this and this. And of course it was the linkage between the two. Paragraph 58 of the judgment, page 3872, is where the court concludes what type of evidence they're dealing with. They refer to the three witnesses who give description evidence, and thus a type of resemblance evidence forming circumstantial evidence of identification, this being the combination with the other witnesses' evidence. It was not direct visual identification of Mr. Turakai, thus their evidence does not come within the Section 4 definition of visual identification evidence, and in terms of Adams and Hanson and Henry, no identification warning was required with regard to their evidence.
For myself, Mr. Mander, I would be reluctant to conclude, particularly in relation now to Section 126, that a warning should never need be given. I'm much more attracted to the suggestion in Australia pre the Uniform Evidence Act that it is sometimes required. It depends on the circumstances. Would you like to comment on that?
Well, the Court of Appeal themselves have referred to that at paragraph 94, the last paragraph of the judgment.
But are you happy, are you inviting us to be categorical about this?
Well, I would not seek the board to be any more categorical than the New Zealand Court of Appeal was in paragraph 94, if I can couch it in that way, because there, the last sentence, the Court of Appeal says, Section 126 has no application to description or resemblant evidence, although again, it may be appropriate for the judge to direct the jury on some of the matters set out above at paragraphs 90 and 91, and paragraphs 90 and 91 is the discussion of the Section 126.
Yes, I would be concerned about the board expressing a definite view about the construction of Section 126, which isn't before us, of course, in this case, because after all, Section 4B, the definition, is quite loose, of the kind.
Yes, I'm not contending for an absolute position.
No.
My submission is that
you would in any event say that it's not a miscarriage of justice because there is a warning and it was appropriate in the circumstances.
What the judge did in my submission was more than adequate, and indeed in my submission he didn't need to do that. Defence counsel, as I understand it, didn't ask for one, and indeed there may be good reasons.
I just wonder whether that's quite right, because I do recollect Mr. Barron's, I think in his address to the jury, saying the judge will warn you about Mrs. Dance.
He did, certainly, but he made no complaint to the Court of Appeal of a failure to direct in such terms.
I think, although one doesn't often place a great reliance on this, the trial judge at the end of his summing up did ask counsel whether there was anything to add.
Yes. That's certainly the practice.
I suppose there was an opportunity there if he'd been dissatisfied to say something. Although one tends to say, well, it's up to the judge, really. I mean, you can't simply rely on the fact that counsel doesn't say anything if you miss something out that's vital, but nevertheless it is
certainly not. But the case of Tristram, which is also referred to in the Crown's case, is an example where the trial judge gave an identification warning, and on appeal the conviction was overturned because the judge was purporting to direct the jury that an identification had been made. An identification had not been made by the witnesses.
Yes, so there's a danger of going too far.
So in fact the identification warning had the prejudicial effect of informing the jury or suggesting to the jury that a positive identification warning had been made. That is in the supplementary bundle of authorities at tab 7.
I don't think we need to go there, really.
I'm not sure amongst all these bundles I know where to find that. This is
It's a fairly thin booklet.
Yes.
Paragraph 8, tab 7.
yes.
Unfortunately, the booklet is not numbered, but it is paragraph 8 of the Tristram judgment. And the Court of Appeal states section 44D did not apply in the circumstance of this trial. The case against Mr. Tristram did not depend wholly or substantially on the correctness of one or more visual identifications of him. There was no such visual identification. Indeed, the two service station attendants who both knew Mr. Tristram, one of them being his second cousin, gave descriptions of the robber which did not match Mr. Tristram. Section 344D requires the warning about special caution to be given in the interests of the accused, as the content and structure of the section make plain. And then further down in the paragraph, perhaps 3/4 of the way to 2/3 of the way down, the court continues, the direction was apt seriously to undermine a major plank in the defence case, namely the failure of the service station attendants to identify him as the robber. And perhaps if I can round off this topic by going to the Australian High Court decision of Festa, which is at tab 22, volume 2 of the authorities.
This is a visual identification case, though, isn't it? And this is going to help us very much.
Yes.
Looks as if it might be a dock identification case, is it?
It was a case where
At the court.
no, it was out of the court. The appellants were disguised, and various identifications were made informally, taking the witnesses to a court, asking them to pick out the person, that type of thing.
What, in court? Or arriving?
No, arriving around the public area, that type of thing. The relevant part of the judgment is really the judgment of Justice McHugh, which commences at page 3268. And his discussion, which continues on through to 3271. And he discusses the different categories of identification evidence, the distinction between positive identification evidence and evidence of similarities between the accused and the perpetrator of a crime. At line 55 on page 3268, he refers to positive identification evidence as often proved to be unreliable. The court has insisted that where identification evidence, direct or circumstantial, represents a significant part of the proof of guilt of an offence, trial judges must warn juries not only of the potential unreliability of that evidence, but also any particular weaknesses in the evidence. He goes on, unfortunately, another class of evidence is sometimes called circumstantial identification evidence. It is evidence that asserts that the general appearance or some characteristic or propensity of the accused is similar to that of the person who committed the crime. He then goes on to describe another form, as I recall, of circumstantial evidence.
Well, 57 is helpful, isn't it? I mean, there's a little bit of this in the present case because of distinctive mark or build and that kind of thing. And what they're saying in 57, or what he's saying, is it doesn't have the potential unreliability of a positive identification evidence, and therefore an automatic warning is not required.
Yes.
But one's still left with the point that there may be situations in which, nevertheless, a judge should be careful to give some kind of a warning.
That's correct. That's correct, my lord. That there may be situations where, because of the nature of the description given, or the circumstances require a warning. But also that they're saying where a witness claims that the facial features of the accused are similar to those of the perpetrator. So that is a positive assertion, linking what they have seen with almost a comparison. And certainly Mrs. Dance in this situation did not seek to make any comparison between her description and then the person that the Crown was contending she was in fact describing. Yes. So her evidence did not go so far as to positively state that the person she saw was similar to the person, to the accused.
Well, it's a fairly short point, and I'm quite anxious that Mr. Hislop should have a full opportunity to reply, so I don't think we need dwell much longer on this unless there's another authority you wish to bring to our attention.
No, the only point I'd make is that His Honour Justice McHugh goes on to give an example of where the Queensland Court of Appeal, a case of Zulo, where a conviction was overturned on the failure to give an identification warning, the witnesses having described the person as a man in a red shirt. And Justice McHugh made it very clear that in his opinion Zulo was wrongly decided on this point, should not be followed. There was no more danger of the witness being mistaken in giving this evidence, that is his description of the person that he'd seen, than in most other forms of evidence. So in my submission, the High Court of Australia, at leastwise His Honour Justice McHugh, was not saying anything beyond the orthodox in my submission, and is not in my submission support for the proposition which has been put forward on this appeal, that a full identification warning should have been given in this case.
Yeah.
Can I turn briefly now, with your Lordship's, my Lady's leave, to the remainder of the Crown's written case, which attempts in a very summary way to encapsulate the most important parts of the rest of the Crown case. And I don't intend to spend a lot of time, there is not a lot of time to do so, but I wish to just highlight two parts of the Crown's case which, in my submission, were important pieces of evidence. The first is that which is referred to at page 4133 of the respondent's case in paragraph 303, and that is the forensic examination of the window that was the apparent point of entry, which undoubtedly had been forced after the murders, was strongly supporting a staged scenario. And it's perhaps worthwhile to take your lordships, my lady, to the photographs again. The photographs at tab, perhaps starting at tab 2. And in particular, photographs 21 and 22. And there we can see it's at page 21 of the booklet. And there we can see the scene as it was at the commencement of the police investigation, with the window ajar and the sliding door open, and reference to the window lock having been broken. The page 22 shows the lever broken, and it also obviously shows the window. I take your lordships, my lady, now to photographs 27 and 28, which are in fact under tab 3. And what we can see here is the blood stain that was left on the outside of the window frame. Over the page, some further blood, clearly being blood that had been smeared onto the window on the upper part of the lower window frame. The photograph on the left-hand side shows the middle window having been removed, and there is further photographs on page 29 showing further blood and where it was located. So it was located both outside on the window frame itself, on the window frame beneath the window that opened, and there was a little bit inside the frame. The short point is that this was Mrs. Lundy's blood, and it was, in my submission, a very significant piece of evidence, because the window must have been forced after Mrs. Lundy and her daughter had been killed, in my submission. No explanation was proffered in the trial, and it was a silent and standing piece of evidence. One cannot conceive of any reason why an intruder would have gone back to the window. The window is open. The intruder has not attempted to close the window to cover up. The sliding door has remained open. So the intruder has not returned after the killings to try and show that the house is all locked up. Nothing to see here. This, in my submission, was a very strong piece of evidence for the Crown, pointing to a staged breaking and entering. The other piece of evidence which was particularly strong in my submission was the evidence relating to a connection between the appellant and the murder weapon. And again, it's most usefully illustrated by reference to the photographs, perhaps starting at tab 13 in the photograph booklet.
I don't have numbers on my tabs.
I'm sorry.
So if you could just give me the page.
It's
Page
chapter
95.
13. Oh, sorry?
Page 95.
95. I think the tabs correspond to the chapter numbers. Would that be right?
Yes, they consecutive all the way through the page numbers.
So this is the tools and the paint.
tools.
Not only one colour, but two colours of paint on the, which suggests that the tool that was used was one that came from his toolbox.
That's correct, my lord, yes. So the photographs show the way in which the tools were marked. This is the appellant's tools kept in his garage, were marked with orange and light blue paint for identification purposes, to mark that they are his tools. We go now to page 127 of the book of photos. What is depicted here is a piece of what was described as cardboard or paper with a blue paint on the top of it. This was located, it's very small, and it was located underneath or adjacent to Amber's body. At page 128, what we can see here is here and other matter collected from the autopsy table. A sieve was placed over the autopsy table, and debris from the body, when it was washed, was captured and retained. And what we see here, again, are flakes of orange paint and blue paint from the autopsy table of Mrs. Lundy. Page 129 is another representation of paint fragments collected from the autopsy table of Mrs. Lundy. The photograph on the right is a piece of bone fragment, again taken from the autopsy table, about which evidence was given at trial of paint having been smeared into the bone itself. And evidence was given of the identification of paint in that bone fragment. Page 130 shows paint fragments collected from the plastic bag that was over the top of Mrs. Lundy's head, her body, and on the right it shows a piece of paint that was collected from the similar bag that was placed over the head of Amber. Page 131 shows or summarises the result of the forensic examination, the details of which are set out in the appellant's case at paragraphs 309 through to 315.
Respondent's case, I think you mean.
I'm sorry, the respondent's case.
Yes, but still, it's clear enough.
And the paint comparison depicts the forensic matching of the paint fragments from the plastic bag on Christine Lundy's head with samples taken from the paint used, the orange paint in this instance, used to mark the appellant's tools. Page 132 shows again the paint fragment recovered from the plastic bag on Amber Lundy's head, and the forensic matching that took place not just with the blue paint from the blue stripes on 3 randomly picked tools from the appellant's tools, but also with a tin of dry paint, pale blue, located in the garage, and which had obviously been used to mark the tools or to paint the tools. Page 133 is again the same type of forensic comparison that was made. Both the blue and the orange fragments taken from the liquid from the autopsy table of Christine Lundy matched again with the tools and the paint tin. Page 134 is the linkage of both blue and orange paint located in the fragment of the bone recovered from the liquid from the autopsy table, again with the blue tin of paint and the tools. And page 135, what we can see in the left-hand photograph is in fact what is depicted on page 127, which is the paper fragment with paint on top of it. And again, the linkage of that item with the blue paint on the tools and the paint tin.
Now, I think in paragraph 315 of your case, you say that these products were kept in a locked place, and the place was found to be locked after the murder, and the key to it was underneath her bag on the kitchen bench. So
that's correct.
The query is whether an intruder would have left the position as it was found to be after the murder.
Yes, the garage was secure.
Yeah.
And the keys located on the kitchen bench. There was no indication of any type of break-in of the garage.
Was there any suggestion that any tools had been left out in the house?
I do not recollect whether any suggestion was made. I'm not sure which witnesses, if any, could be asked that question and to give a...
Well, the defendant, for a start.
Well, no doubt it could be posed.
I don't know whether that's what he asserted or not.
I honestly cannot recollect. It may be something that is likely that he might have asserted. But I'm sorry, I can't.
Well, we will have a reply in a moment or two to direct us to any
And
evidence.
then a friend can refer to that evidence and reply. So be it. The other evidence is set out in the case, evidence relating to the ability to drive between Batoni and Palmerston North in the requisite time. Perhaps one important feature that one can lose sight of is that, of course, there was no end point. There was no definitive end point in the time frame as set by external evidence. So the 8:30 time is the time that the appellant chose to answer his telephone, he having not answered it previously. So if, in fact, it took him a little bit longer on the Crown's theory to get back from Palmerston North, perhaps say at 8:45, and then answer or return the call He was the person in charge of setting the time frame. I'm not making myself clear.
So the initial call, the call just around 6:30, was his call, was it? He initiated that call?
No, it was a call that he received from the family in Palmerston North.
Ah, right.
The 8:30 one was the one that he returned the call to his
That's right.
friend.
I think it was 5:30 rather than 6:30.
Yes,
wasn't it?
5:30.
5:30.
You've got 5:30 a call from the deceased wife to the defendant.
Yes.
That's right.
And am I right that that's cell-sighted at least somewhere in Paterney?
Yes, that's correct.
Right. And the next one is 2028, isn't it? 8, in other words, 8:30 as near as makes no difference.
Yes.
And whose call is that? My note, and it may well be wrong, is that that's his call to a man called Mayer.
That's correct.
Or Meyer, and that it was cell-sighted outside the motel.
That's correct, my lord.
Is that right? So it is back in Paterney.
It is.
At least his phone is, and on the face of it, therefore, he is. At least in this instance.
Is it as precisely located as that? I mean, I've understood he wasn't in the motel, and presumably the motel doesn't allow people to receive calls from outside. Was he just in the street outside the motel at the time?
Well, the evidence was that the 8:28 p.m. timing when he retrieved his voicemail was received on what was described as the Ellistown 2 site.
Right.
Which is the street outside the motel, somewhat to the north, yes?
It's to the north.
Yeah, to the north.
That's correct.
Mm. And so did you say voicemail?
Yes, the evidence was that he, at 8:28 p.m, he retrieved the voicemail message that had been left on his phone when he hadn't answered the earlier call from Mr. Meyer,
Yes.
which was at 8:13 and went to voicemail.
Right.
Now, that call at 8:13, because it goes to voicemail, doesn't register on a cell site.
Right.
So there is no evidence as to where the appellant may have been at the time that the message was received.
But do you accept or don't you that there is evidence that he was at any rate in Paterney or thereabouts at 8:28? Or is that not what that call shows?
Well, only so far as that he was in the area of Ellistown 2 at 8:28.
Where's that?
That ma'am is it's within. It's slightly to the north of Paterney. It's not very far away.
But he's not going to go north, is he? Because that goes up the Hutt Valley.
Oh, he would. Yes, ma'am. Over Haywards.
Oh, over Hayward, yeah, I see.
But the point is, Ellistown 2 is part. It's in Lower Hutt.
Yeah.
It's in southern Lower Hutt.
Yes.
So the Crown case was that he was getting very close to the motel.
Yes.
Nearly back, is that
Nearly
your
back,
case?
felt confident
Right.
to make the phone call and it would register thereabouts.
Right. Yeah. Now, we'll have to hurry up because it's very important that the reply starts no later than 3 o'clock.
Well, I won't dwell too much further. The evidence is set out. The bracelet from the jewellery box, there was evidence that the bracelet found in the vehicle, a jewellery box, the only item taken in the whole burglary was a jewellery box located in the bedroom. And there was evidence that suggested that the bracelet was in fact Amber's, but that was kept. Some of Amber's jewellery was kept in Mrs. Lundy's jewellery box. And that evidence is set out in the case. There's the evidence, of course, of Margaret Dance and her description of what she saw that evening. Again, it's set out in the case.
And then we've got some material about possible motive, which you deal with in paragraphs 378 and 385.
Yes, and I need to clarify this. The Crown case is not that, and never was, that these killings were committed for the purposes of recovering life insurance.
Right.
And indeed the evidence was that although there had been an increase in life insurance cover, the policy document had not been received, and therefore the policy was not live. And the Crown case was that the appellant was very quick to point all that out. More pertinent, however, was the fact that the appellant had engaged in a very optimistic, having regard to the means of the appellant, investment in purchasing land in the Hawke's Bay for some $2 million, purchasing grape vines, again at great cost. The property contracts were unconditional on finance, and as is set out in the case, in fact, on the 28th of August, he was contacted by the vendor's agent to inform him that settlement was in 2 days' time, and he would be liable for all this money. The contest at trial was that, well, the vendors would just keep the property and that would be it. But it is clear that the appellant was effectively facing financial ruin.
There was substantial penalty interest that was payable in any event, wasn't there?
There was, ma'am, yes. So there was a lot of evidence given at trial, and to summarise it, it is apparent that the appellant was under severe financial pressure, which of course can never possibly make explicable the inexplicable. But it is clear that also that Mrs. Lundy was not involved in this, that there were strong indications that she didn't agree with what was happening. And clearly this was all coming to a head around this time. Now, it was put no higher than that, and could be put no higher than that.
Well, there we are. That's really you've set it all out quite neatly in your case. In the few remaining minutes, can I just ask you to contemplate the possible disposals of this appeal? And plainly, your invitation to us is that we invite Her Majesty to dismiss the appeal. But supposing we were not prepared to do that, what are the options open to us?
Well, in my submission, of course, I do make that submission. However, in my submission, particularly in respect of the evidence relating to the brain tissue, before there can be any type of consideration of allowing the appeal, there needs to be examination of the evidence that has been tendered to determine whether or not it is of sufficient cogency to give rise to a substantial miscarriage of justice. In fact, in my submission, firstly, to determine whether or not, it not being strictly fresh evidence, it should be admitted, while I accept that appeal courts will examine that type of evidence and examine those issues as an amalgam, receiving the evidence and examining it. Yeah. But as I spent perhaps too long emphasising, it is the appeal court's responsibility in my submission to make that determination and to evaluate the strength of that evidence and to determine where ultimately it gets to. And in this case, an example of that may well be that the appeal court determines that the jury perhaps should have known that what Mr. Miller did was novel, was a new use of IHC. And they should have been informed about that and made aware of it. But that in fact the evidence that is heard on appeal, that's as far as it goes. It certainly no evidence has been tendered to say that it is not brain tissue. So in that situation where the appeal court ultimate evaluation is all the evidence amounts to is an indication that the jury should have been assisted by the knowledge in terms of the weight they put on the evidence that this is something new. Now, in my submission of that, if the appeal court got to that point, then I would seek for the proviso to apply.
It's more than weight. I'm sorry, but it's more than weight, though, isn't it? It's whether to accept it at all.
Yes, indeed, Mark.
Because, yeah, thank you.
Indeed. Mm-hmm. The point I'm seeking to make is, however, if the appeal court makes a higher, puts the evidence on a higher plateau than that it is very compelling evidence showing bad science, then clearly the proviso could not be applied to it. That if the appeal court, after examining the evidence, gets to the conclusion that Mr. Miller's analysis is flawed, shouldn't have got before the jury. I obviously, in that situation, can't expect the proviso to apply. But what that illustrates in my submission is the importance of this evidence being examined and evaluated to see what does it ultimately amount to in terms of its effect, it not being fresh.
Now, as far as the appeal court is concerned, I suppose they can either dismiss the appeal or they may allow it, and there's a question then for them would be, should there be a new trial?
Well, in my submission, if the board was minded to allow the appeal, certainly my submission would be that there should be a new trial.
Would that be for us to order? I mean, supposing we were, this is purely just hypothesis, but I mean, supposing we were to reach the view that we should allow the appeal, would it be open to us to make the order, as was done in Bain, I think?
Yes.
Making sure, of course, that the appellant remains in custody for the time being. But it would be that type of order that would be made, would it?
It would in my submission.
Well, thank you very much. Is there anything else you would like to add before you complete?
I am just very mindful that Lord Kerr asked for the references to the evidence relating to occlusion, and I can give those references to the board. Firstly, at the bundle, I'll just give these references. Bundle at page 761, lines 21 to 31. However, Mr. Sutherland also gave evidence about the amount of blood on a person from a swinging weapon is very variable. That's at page 826, lines 18 to 24. However, he also says that it's likely the killer would have blood on him, page 827, line 30 to 828, line 4. And also the reference to Detective Sergeant Grantham's cross-examination is at page 79, line 31 to page 80, line 10, where he's actually invited to give his theory or thesis as to how the brain tissue got onto the shirt, that being at the time that it is put to him that he may have planted it. A very, very small point. In the beginning of this appeal, there was a question asked as to the evidence relating to Mrs. Lundy sleeping naked. Now, the only evidence we can find is that coming from the appellant himself. His mother, Mrs. Lundy's mother, said that to the best of her knowledge, Mrs. Lundy wore pyjamas, and that's at page 132, line 13. And if I can just have the board's indulgence on a point that may be of some import, and that relates to what was received by Dr. Cynic from Mr. Behrens. And there is a letter from Mr. Behrens. It is in the bundle at page 2785.
Page number again?
2785.
Yes.
He has received 2 sets of photos and photo micrographs, as well as a schedule of photo micrographs from the police. There's no contest that he obtained the full set. The issue arises as to what Dr. Cynic was given.
I'm sorry, so that's the photos, those are Dr. Miller's photos, yes?
Yes. Mr. Behrens' letter of instructions can be found in the bundle at page 1811. 1811 through to 2, 1811 and 18112, and it encloses, quote, a booklet of the evidence the Crown proposes to call. This clearly includes colour photographs because he asks for these to be returned. Unfortunately, Professor Cynic's reporting letter of 1813 does not refer to the material she viewed. Of course, in her affidavit for the purposes of this appeal, at paragraph 8, found in the bundle at page 1900, she said that she was not made aware that it was only being provided with a selection of photographs which Dr. Miller had taken. But of course that assumes the very question as to what photographs she actually received. Mr. Behrens has not been asked about whether or not Professor Cynic was given a full set of photographs. He was asked why she failed to examine the slides themselves.
Now, you're taking rather a long time over this.
Sorry, and that completes it. The short point is that the letter from Mr. Behrens would indicate he sent his colour photographs that he's received. I need to have them back.
Right.
Which would indicate that he's actually sending a full set.
Yeah.
I apologise. And that completes the submissions for the respondent.
Thank you very much. Ms. Markham, would you like to add anything? No, Mr. Hislop.
I'm not going to accuse my learned friend of playing bad life, but we're getting there. We've got a very short time to cover a lot of material that we anticipated this. What we've done is prepared, in essence, a speaking note. And obviously we put it before the board. It would permit me to move very quickly.
Well, I think that, I don't think you need to explain yourself very much. I think we can receive that, provided, of course, your opponents have received it. Yes. Thank you very much.
It's in 2 parts. One we prepared overnight and one at lunchtime.
Yeah, thank you. Yes, I'm sorry we are pressed. We have to rise at 4, which means 5 to 4 by that clock.
Yes, I've already quickly
Yep.
hopefully deal with the matters. The first document is the more substantial one, and it's headed up No Other Time Window, paragraph 1. My lady, my lords, this deals with the tactical decision of trial counsel to not call it time of death.
Sorry. Yes. Time of death evidence, and the suggestion from the respondents is that one of his concerns must have been that there were other, in effect, worse windows available on the evidence, and it suited the defence to have the 7 p.m. window and not the others. We say this is and could not on the evidence be correct. At A, we set out why. There were no additional 3-hour pre-midnight windows. The 8:29 p.m. telephone call that placed the appellant in Petone, in fact, lasted 27 and a half minutes. So that would put...
Is he cell-sighted at Petone throughout that time?
Yes. Right. Excuse me? Well, I can...
No, don't go into it.
I will deal with that.
Don't go into it now.
No. We can deal with that. It comes for the brief of the telecom engineer, Peter Farland, when read with the cell site analysis. But we can deal with that briefly when we come to the proviso very quickly.
Have we been provided with the evidence of Peter McFarlane?
Did that come in yesterday?
My Lord, we have it in the bundle, and yes, oh, I see. What we've done is we've put, and it ought to have been included in the record, but we've put the brief of Peter McFarlane, who in fact was called at trial, and in it, it's simply...
Well, all I want to know is where is it?
There must have been a schedule of calls showing the maps and the cell sites.
There was, and that is...
We're going to get it now. Good.
Well, you won't get a schedule, but we'll get the proof that it was a 27-and-a-half-minute phone call.
Thank you. Yes,
Thank you. So that, of course, would put the appellant in Wellington at 3 minutes to 9 o'clock. So that would give him less than 2.5 hours to get himself back to Palmerston North, park outside, commit the killing and return to Petone. And the point is this, and we deal with it at B, there was no post-midnight window because, of course, I'm sorry, it's
Yes, go on. Go on.
There was no post-midnight window, as Mr. Lundy was known to be in Petone at 12:37 the following morning, and again, that's we refer to Mr. McFarlane's brief. This is consistent with the alibi, the evidence in the trial from the escort. That's volume 2, page 490, and that puts Mr. Lundy with the escort at 11:40, between 11:40 and 12:40. And of course, dealing with the time of death evidence that we have and stomach contents, if he was to leave Petone at 12:37 after midnight, he wouldn't get back to Palmerston North by 2 a.m, and therefore you would have empty stomachs on the 6 hours that we know was the outside for the emptying of the stomach. So we respectfully submit that on the evidence, counsel must have known there in fact was no other windows but the 7 p.m. Moving on to address Martenga if we can. the respondent suggested that the jurisdiction to receive expert evidence on appeal was very tightly circumscribed. My Lady Chief Justice yesterday suggested the exposition of the relevant principles was rather austere, and frankly we agree. We've addressed that, the board will recall, in our case, and that is at our paragraphs 45 and 46, where we provide the well-established line of authorities for the proposition where evidence was not led at trial because trial counsel relied on the advice of experts he or she consulted, including that such evidence did not exist. The freshness criterion will readily be satisfied. We don't take the board to the English decisions because we don't understand them to derogate from that proposition. The respondent suggested in our paragraph 4 of our note that the hurdle which the appellant must surmount in such circumstances was a very high one. He put it, the evidence should have to be so compelling and cogent that it renders the evidence put before the jury as wrong or unsustainable. With respect, we say that doesn't represent the law. What the respondent has done is conflated two concepts, the concept of credibility and, of course, the further step as to whether that evidence, once received, has the consequences that renders the verdict unsafe. With respect on the issue of credibility, we would submit, especially in as to the issue of the brain tissue, we have put before the board internationally recognised experts with impressive and proven pedigrees, and we say that credibility must be met in those circumstances. We respectfully submit that the issue of credibility and the determination by oral evidence before the appeal court going to issues of credibility are really reserved for cases quite different than this one, with respect. We respectfully submit that if the criterion of freshness is met, if the issue of credibility is met, then the question of cogency is for this court, and the decision as to any dispute between the experts is something for the triers of fact, and that's the jury, in our respectful submission. And that, we say, is a proper reading of Martinga. And we set out that at our paragraph 8. In paragraph 9, in the instant case, we would respectfully submit that this is a case where it is clear on the face of the evidence before the board that a guilty verdict was not inevitable. And we repeat our proposition to the extent that the board is satisfied there is a general and credible conflict between these experts. It's a matter which falls to be resolved by a jury by virtue of retrial. We then refer to the case of Blake and Tech, and I hope a copy has reached your lordships.
No.
It's just coming. I'm sorry.
Okay.
There was discussion yesterday, and I think it was my lady who asked whether or not there were any further examples, or in existence any examples, where IHC had previously been utilised in a forensic context. This, in fact, is a decision where it has. It's an American decision. It is the judgment of the Court of Appeals of Oregon, and it is of some particular interest insofar as the deployment of IHC is concerned. The head note HN4, we see at page 2, is interesting, not least because it gives particular emphasis to the court as gatekeepers because of the particular influence such evidence might have on a jury. Evidence perceived by lay jurors to be scientific in nature possesses an unusually high degree of persuasive power. And it goes on, the value of proffered expert scientific testimony critically depends on the scientific validity of the general propositions utilised by the experts. Now, turning, if we may, to page 9, and the particular passage we won't read, but we invite the board to read it in due course. Right-hand side of the page, that column sets out in some detail the failings of IHC in that case, and it has a particular resonance to the complaints by Professor Sherd insofar as the reliability of Dr. Miller's methodology in this case.
I've a recollection that there are authorities in the Canadian Supreme Court adopting a similar sort of approach to other scientific techniques. Obviously,
yes,
not IHC, but...
My Lord's quite right. I've forgotten the name of the case, but
it's the
gatekeeper principle,
yes.
as it pertains to the acceptance of scientific, especially novel scientific.
Particularly in the United States, the two cases of Fry and Dobert.
Thank you, my Lord. Thank you. And so that authority certainly was the only authority that we could locate insofar as IHC is concerned, and it's particularly pertinent on the facts, and it's particularly pertinent on the failings identified, because they're talking about lack of control, lack of repeatability, lack of identifying and testing the controls, the lack of specificity of antibodies, all matters that primarily concerned Professor Sherd. And so this is an example of a case where IHC procedures, evidence relating to that, was excluded as too unreliable in a forensic setting.
Yes, well, we better move on, I think.
Yes. The Miller slides, please, at paragraph 13, suggested that all Sherd, Whitwell and Gatters and Squire's criticisms are really argumentative qualification. We don't accept that at all. We commend that the board look at Professor Sherd's affidavit. It's at volume 5, tab 12, and we've identified the paragraphs within that affidavit that we can commend the board look at. With respect, this evidence is not merely argumentative. It goes far, far further than that. This evidence takes real issue with the reliability of the processes of Dr. Miller. At paragraph 21, we identify and deal with the respondent's proposition that really Dr. Teo doesn't matter because he was looking at a different slide. Well, first of all, we don't accept that at all, but logically that doesn't make sense in any event, because in essence what we have is the ESR slide was 59 days kept in uncertain conditions. We know, in fact, the Miller stains, they were 160 days kept in uncertain conditions. And moving to Professor Sherd's affidavit at volume 6, tab 26, we've referred to a number of paragraphs there. She deals with the Doyle letter at 21. Pausing there for a moment, paragraph 25, Professor Sher deals with the limitations of Professor Gowan's evidence. It's our respectful submission on a careful reading. We can see that what Professor Gowan in fact saw was, one, the slides, but what he didn't see was the whole 107-page report of Dr. Miller. So therefore, Professor Sher's is justified in his criticism that what Professor Gowan wasn't exposed to was the methodology used by Miller. And we address that in particular at our paragraph 29. At paragraph 34, we address air-dried specimens. And the point is that, again, that by the time Miller gets the stains, we know that not only have they been subjected to uncertain conditions, but they've been rehydrated twice. At 35, we deal with D.S. Granthon's notebook and the related correspondence, and the point has already been made by the board about what the notebook did not contain. And so moving on to then the second document, before returning to the main one, we deal with the trial evidence of Dr. Sinek. Dr. Sinek was directed to a narrow issue of whether what was accepted to be brain tissue was deposited wet or dry. And we invite the Court v. Ball to paragraphs 8 and 9, volume 5, tab 11, which addresses her ignorance of the, in effect, provenance of what was she was being asked to consider. And of course the point's made that, well, she had Miller's photographs, but of course what she didn't know at the time was that the presentation of those photographs were subject to selection, the selection that Professor Sherd criticises, because of course all the negative findings weren't posted within that report. So that's an important distinction. At paragraph 6 over the page, we refer to the significance of the time of death evidence. It strongly undermines the firm impression which a jury were left that despite trial counsel's cross-examination, that any uncertainty in the forensic timing was in the order of minutes, not hours, let alone, as Professor Cicillatera and Diamond now explained, 6 hours. And we make submissions in relation to that at 7 and 8. At 9, we address Mr. Kleinge's tests. Our learned friend sought to dispute Dr. Watts's evidence that Mr. Kleinge's tests results accorded with his own and established that CAT did disorder the registry files. And so we've set out in some detail the chronology which we commend to the court of just how it came about that we received the notes, the examination notes, and what in fact they purport to be. And we address that at 11, 12 and 13.
On the point of 13,
yes,
if, as apparently, according to the appellant, was her practice, Mrs. Lundy checked the emails before she went to bed, would that have generated modem
To be frank, I haven't got the expertise to answer that. I would suggest that she would have to operate the modem where, in essence, go onto the internet. Yeah, or check it on the laptop.
And as soon as the computer is still operating, still running, it had been
Yes.
switched on, left running on. Yeah. But something would have to be done to activate it.
Yes, quite. If the internet was running, then one would imagine no footprint. But if one had to activate the modem by going onto the internet, then one would reasonably suggest forensic footprint.
And Peacock said the accounting program left a forensic footprint.
Yeah. I think it's I'm helpfully reminded on the issue of forensic footprints in Peacock's report, and we've referred to it in our submissions. It's interesting to note that, in fact, the accounting systems on the desktop were closed at 10:51. So a minute before the desktop was turned off, the accounting systems were turned off.
Yes, he also says there wasn't any use of the machine from 20 to 4 in the afternoon until those two events, which are more or less simultaneous.
As I recall, what he said was there was no modem use.
No what?
From 340.
No modem use. It's a dial-up connection, presumably, in those days.
Yes.
I'm not sure. I think he says no use of the machine, doesn't he? Perhaps not.
Doesn't accord with my recollection.
Right, thank you very much. I'll check.
Yes. I'd stand corrected if I...
No, we'll check.
Yeah.
Moving on to the laptop, my learned friend took the board to the interview conducted on the 14th of September with Mr. Lundy, in which he said to be aware of the potential significance of the laptop. This is unsurprising because, as explained in paragraph 180 of our written case on the 8th of September, a week previously, he was approached by a detective and asked to give permission for his computers, and that's plural, to be cloned, which he readily gave. No doubt the reason for this request was explained to him. A copy of the consent is appended to Dr. Watt's affidavit, and this is confirmed in the search warrant application sworn by D.S. Grantham, and the court can find that at the applicant's supplementary bundle, tab 11, paragraphs 25 to 27. Thus, by the time the laptop was returned to him, he could have reasonably assumed that whatever forensic interrogations were necessary had in fact been conducted. Yes. I'm helpfully reminded that in fact the evidence was that it wasn't in fact returned to Mr. Lundy, it was in fact returned to his brother-in-law, because his brother-in-law was anxious to gain access to his tax affairs in order that he could meet his return obligations. We simply draw attention to our submissions at paragraphs 16, 17, and insofar as 18 is concerned, as to the significance of the laptop, it's not right to say that it would in any event leave the appellant in no better position were it available. If it's shown a shutdown period consistent with that of the desktop, and there was no evidence, of course, of manipulation, then of course that would be strong evidence supportive of the appellant's case for the later time of death. And that would be the significance of that. Moving to the matters of the proviso, and if I could take the board back to the main bundle, please, that I was referring to earlier, and to page 13 at the bottom.
This is really your submissions, the point I raised with you at the end of your main address, the points raised at the end of the the respondent's case with a list of various factors.
Yes.
Yeah.
Yes.
Excellent.
Yes.
Thank you.
Yes. We address Amber's blood, and in fact, we've already addressed that during the course of our opening our appeal yesterday and the day before, so we don't deal with that. But to deal with the first of my learned friend's point this afternoon, the alleged stage break-in, we deal with that at page 14 of paragraph 7. Your attention has already been drawn to the page 28. The evidence in trial was it was possible to gain entry to the house by forcing open that window and reaching in and opening the ranch slider. It was possible to force open the window from the outside and thereby open the ranch slider, reaching in and unlocking the latch. The ranch slider was, of course, found on the evidence open the next morning by a courier who had arrived very early in the morning on the 30th of August. At page 30 of the photographs, and there's no need to take your lordships to it at the moment, we see V marks on the outside of the window frame, and the evidence from the police at trial was this was consistent with marks that might be left by a jemmy or a small crowbar. Christine Lundy's blood, of course, is indicated in photo 28, bottom right hand near the corner of the window and on the bottom of the frame and on the inside lip. The evidence we respectfully suggest is consistent with an intruder gaining entry prior to the killing and the victim's blood being deposited by secondary transfer, as the evidence was, as he leaves via the ranch slider, partially shutting the window as he leaves. One walks past...
Because he partially shuts the window. Yes, I see.
Walking past, and the interesting...
Why would he?
If one looks at the photographs, one's going out of the... If the window's wide open and one's going out of the ranch slider, it's their drop hand, entirely consistent. And the interesting thing about that consistency is this, and we addressed this.
This is an intruder who's killed a woman and her daughter. Why would he trouble? Surely he'd want to get off the scene as quickly as possible.
Yes, and it would take no time at all to, as one brushes by that window, to give it a flick. It is equally as consistent as the scenario as posited by the Crown. And one might reasonably ask oneself this: if this was a premeditated, carefully planned murder by Mr. Lundy, do you seriously think he would be stupid enough to have deposited blood in the position that he did? It beggars belief, with respect. But at hour 13, what is of interest is the Scenes of Crime officer at trial gave evidence, and it's at volume 2, page 701, line 605. He finds a partial palm print on the ranch slider. During the course of the investigations, all personnel and visitors to the house in the lead up to and after the killings were fingerprinted for exclusion. And there was a very long list of people. And of course, the partial palm print was never identified. So we respectfully suggest that this evidence certainly does not make a significant difference to the Crown case. The murder weapon we can deal with shortly. If the victims were killed by one of the appellant's tools, of course this finding of its own could never put the weapon in his hands. And we expand on that over the page at paragraph 16. On the 30th of August, he was interviewed at length by the police and made a lengthy statement. At the time, he could have no knowledge of the finding of the paint flakes that on the prosecution case matched up with the paint markings he had on his tools. He was asked whether he kept his tools, and he told the police, he was asked where he kept his tools, and he told the police in his garage, which further questioning established he kept locked. He was also asked whether his tools might sometimes be left lying around in the house, and he said yes, if he or Christine had been using them. And at paragraph 19, the evidence from a friend of the family at trial was that the conservatory area, especially in the Lundy household, was frequently untidy, cluttered with furniture, boxes, toys and different items. In light of what the appellant told the police when he had no idea of the full significance of the question, the murder weapon, we respectfully should suggest, or potential murder weapon, would have been or might have been accessible to a stranger or an intruder. And the point is the obvious one. The evidence as it was could never put by itself the murder weapon in his hand. We address the issue as to the tomahawk at paragraphs 21 through to 25. At 26, we address issues of the petrol consumption, and then we move to the cell site. And as it has been addressed by my learned friend, can I deal with that shortly? The cell site evidence, far from adding strength to the Crown case, we respectfully submit in this case, if handled correctly, ought to have severely weakened the Crown case. The appellant stayed at the motel, at Foreshore Motel in Tony, and the evidence was that he would stay there quite often. The cell site coverage for that motel was a little unusual because the hotel was on the evidence was on the corner of I think it was Nelson Street and Esplanade Road. And a little unusually, the cell site coverage for that hotel, in effect, was on the cusp of 3 different cell sites. And this is demonstrated within the evidence in the trial by the technician when he gave the evidence that if one made a call from inside one of the motel rooms, one could be on WPET1, but during the course of the telephone call might switch to WPEX2. And the evidence was, well, that wasn't surprising because they were almost of similar strengths. The evidence also was that if one moved to the northern entrance of the motel, and that would have been on Nelson Street, and then of course one's dominant coverage was the Alistown 2 site. So a very interesting configuration of cell sites. And the point is this. When interviewed on the 30th of August as to his movements that night, there could have been no way in the world that the appellant would have known that somewhat unusual configuration. And yet the account of his movements, we respectfully submit and set out in our document, is consistent with a movement from one cell site to the other. And so far from the cell site lending strength to the prosecution case, in a very peculiar way, we respectfully submit it in fact lent considerable support for the account that the appellant gave. As to inferences that can be drawn from two cell site readings, the one at 5:30 and the later one at 8:28, we address at 48. We respectfully submit that two cell site readings on their own, seeking to draw inference from them, is really no good inference at all, but speculation. Because, of course, doubtless as the respondents know, cell site analysis, of course, is a very useful tool where a user of the telephone is to prove where the user of the telephone is not, as opposed to where he is. And so it has its very real limitations. So to draw the inferences that the Crown sought and the respondents seek with the greatest respect is of little weight, and it certainly does not add much to their case. My learned friend addressed the bracelet. We addressed it at paragraph 57 of our further submissions. And there's a real risk in this case, we say, in relation to the bracelet, is to drawing any particular inference. This is from what the defendant was saying about the bracelet. And it's evident when one reads both his interviews, and especially the first one, that he's not shown a photograph of the jewellery. He's not shown the jewellery itself. He's given a very vague, as we set out, a very vague description of the bracelet. And it's far from clear that he knows what piece of jewellery is being referred to. He obviously believes it's a piece of jewellery of his wife. The other evidence in the trial was that the bracelet, in fact, was not Christine's style. It was too small for her, and it was even too small for the child. And if that's right, then, of course, if it's not connected to either the Christine Lundy or her daughter, it can't be connected to the jewellery box, and it really has very little probative value, and certainly doesn't lend any particular weight to the prosecution case. At paragraph 26, we refer to Margaret Dance insofar as the proviso matters are concerned, and draw attention to the limitations.
Is your criticism, you're really not dealing at this point with the criticism of the judge's direction. This is just dealing with its significance for the proviso, yes. Is that right?
Can you get me Festa?
It's really the proviso point.
That's the proviso point.
Yes, right.
Yes. And we simply set out therein the limitations. Still on the proviso, we deal with the financial position in some detail, and it begins at paragraph 68. The overwhelming evidence in the case was this was a loving and happy couple, and that the appellant was adoring of both his wife and his daughter. And we give the particular references at 68 and 69, and indeed 70, about the state of their marriage and what others thought of it. The Lundy's sink business was profitable, and we point to the evidence of that. In fact, around the time of death, both Christine Lundy and the appellant were excited and looking forward to a substantial increase in their profits. That evidence came from the two directors of their main supplier. Apparently, a new product was coming online, they were excited about it, and everyone anticipated that there would be a sharp increase in their income. The respondents in their note We respectfully submit over the play the indebtedness of the family business, Mark Crush Enterprises. In fact, of course, they did owe $110,000 at the 30th of August, but this was really, and this was evident in the trial, was a revolving credit arrangement with their supplier. So it would go up and it would go down, but there was no suggestion that this was an issue, and there was no suggestion that this was not the norm, and the evidence was from the supplier that he accommodated it. That's in relation to the sink business, and we refer to the particular parts of the evidence which demonstrate this and demonstrate the forbearance of the supplier. In fact, the supplier gave evidence as to how they valued the work of this particular company. Over the page, if we may, as to the vineyard investment scheme, we addressed that at 76. The scheme was a scheme we respectfully submit that on the evidence Christine Lundy knew about, and she was, it was something that she spoke about with others, and we make a reference there at 76A to John Myers' transcript, and he said this. He was asked, how often would you talk to Christine on this basis that you have described in the months before she died? I would probably have contact with Christine or Mark regarding Salu Vino, this side of things, once a week. That was one of the investment companies. Possibly maybe a little bit more, depending on what was happening. So what was your feeling when you spoke to Christine of her general mood in these times? Very buoyant. The accountant, David Hopping, he gave evidence, and he gave evidence that whenever there was a meeting about this investment proposition, not only was the appellant present, of course, but also Christine. So it wasn't a case where some clandestine investment was going on behind her back. Nothing of that sort. She participated in the decision-making, and that's confirmed on the evidence. Indeed, the respondents are quite right. This investment scheme was failing, but it wasn't dead, as it were, and the evidence before the court was that the business partner gave evidence that, and we give these citations, volume 1, page 145, that there was every chance that a Mr. Ernest Bland may purchase the vineyard, and that he was due to meet the appellant on the 30th of August 2000 to discuss it. And the business partner gave evidence about the fact that he'd spoken to Mark Lundy on the 29th of August, and that was a 27.5-minute phone call, wherein Mark Lundy was optimistic that Mr. Bland would step up and buy all the shares in the investment scheme. And of course, there was evidence that penalty interest was accruing, but on the evidence from the business partner, he had no doubt that...
But Mr. Meyer had name suppression in this case, didn't he?
Mr.
The business partner.
Yes.
Does that continue?
Sorry. Oh, I'm told from my learned friend that it was made permanent.
Was it?
If that's so... I don't know where that leaves us.
It's not clear why it was. Anyway, however, if it's an order in New Zealand, it doesn't mean to say that this board need continue it. We don't know anything about it.
No. I can't imagine why the order was made, but the important thing about his evidence was, and we pick it up at 78A, of our submission that the assets of the investment company, namely the young grapevines that were growing, had a value of about $240,000, which would have more, on his evidence, would more than have covered what the appellant owed by way of penalty interest. And so we respectfully submit that the respondent seeks to overstate the case of pending financial ruin.
Were they paid for? I did read some of this evidence because it's at the beginning of the transcript.
There was an issue.
Yeah.
And there was an issue, in fact, that on the 29th of August, some very large gentlemen from the Hawke's Bay arrived at Mr. Healy's farm trying to recoup what they believed was monies owed to them in relation to those vines.
Oh.
Whatever happened to those people, I know the police removed them from the farm, but I know nothing more than that from reading the trial evidence. But be that as it may, one of the Crown called a police accountant, Mr. Murphy, during the course of the trial. And with the greatest respect, the respondents now seek to overstate the pending financial ruin in exactly the same way as Mr. Murphy did, and the learned trial judge criticised him for that, and we picked that up at transcript page 239, lines 1 to 40. I hear my learned friend's point in relation to insurance. It's right, however, that the case against Mr. Lundy was opened on the basis that there might have been a financial interest by virtue of insurance. Mr. Butler opened the case for the Crown on that basis, but it's fair to say during the course of the trial it became evident through the evidence of a Mr. Parsons that that could not be. What happened with Mr. Parsons was it was at his instigation that the insurance was increased by Mr. and Mrs. Lundy. They had the opportunity to increase it to $1 million each, but Mark Lundy thought that was far too expensive because of loading in relation to his medical health, and so they settled on a lower figure of $500,000 each.
But I don't think anything was made of this in the closing speech for the Crown. I don't recall seeing it there at all.
As the evidence unfolded, it became patently obvious that Mark Lundy knew that the cover hadn't increased by the 29th of August. Yeah. The point, of course, is made by the Crown, well, isn't it strange that he told his sister-in-law and, his brother-in-law and brother-in-law's wife that we respectfully submit that really is a submission and hope, and really nothing really turns on it, and it's certainly not something that should concern this case by this board by way of proviso.
There's just one point that I probably should have asked the Crown about, and that is the test for the application of the proviso. We're quite familiar with the test in the cases we get from the Caribbean. Can we take it that the test is the same in New Zealand, that had the jury been in possession of all this information, they would inevitably have convicted?
Yes, this is the Martinga point. Yes.
Also, my Lord's judgment in Stafford
yes.
regularly quoted as expressing the correct test to be applied.
We've set that out in our case at paragraphs. Yes, I know, but I'm just trying to flag up the reference. We set that out at paragraphs 45 and 46. Pausing, if I may, for a moment.
I didn't think it quite addressed the point I'm concerned about. But nevertheless, I mean, I don't
It's the Martinga test, isn't it, that you're...
Right.
Yeah.
Yes.
7 and 8.
Yes. Can I take the court to 7 and 8 of our reply note this afternoon?
7 and 8 of...
Paragraph 78, 7 and 8, sorry, not of our case note, but of the substantial note that we handed in this afternoon, the one that starts no other time windows.
Yes.
Once the evidence is admitted, the question becomes whether this renders the convictions unsafe.
Right.
Formerly, this was considered by reference to what the jury might have made of it. However, following Martinga, as we conceded yesterday morning, the question falls to be considered by the appeal court. However, and this is the point that we stress, however, this does not mean, as the respondents suggest, that the appeal court must determine that any conflicting expert evidence at trial is clearly wrong. This sets the bar far too high, and no support is found in the decision of Martinga for it.
But on the proviso test, it's simply that the appellate court must be sure of guilt.
Yes.
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 I think that's...
Yes, that really is.
Yes.
I mean, that's
Yes.
the point.
It's that
Put in.
simple. My Lord.
Well, you've done very well to compress all this
Yes.
as neatly as you have. So I take it that is your
Those really, well, there was one matter in relation to the identification point, and that is, we've really set it out. Can I just stress for the court's note, we pray and aid our earlier submissions in relation to this reliance on paragraphs 8, 14, 57 and 76 in Festa. We respectfully submit no hard and fast rules. The learned judge had a discretion as to what he should say to the jury about the evidence. And clearly it's evident from his note, the summing up, that he certainly, it would seem, he thought that he had already given some sort of detailed direction, and as far as our note's concerned, he didn't. And that's how we put it.
Thank you very much. Well, the board's extremely grateful to counsel on both sides. As I said at the beginning, we're aware that you've prepared this case under considerable pressure of time, and it's been prepared to a very high standard. You've mastered a lot of detail, and you've made it remarkably accessible for us in the way the case has been presented. So our thanks go to those who've spoken and those who've not spoken, who've obviously played a major part in the presentation of the cases. The board will take time to consider what advice they will humbly tender to Her Majesty.